What are 3 things I would never do as an estate planning lawyer? You may have seen other videos where an estate planning attorney will tell you, never have a will, always have a revocable living trust, or something that says there's only one correct estate plan for you. I disagree. In Washington, a revocable living trust might be correct, but it might be terribly wrong for you. You might want a will with an asset protection trust, or you might want a will that avoids probate, and that can be done through other estate planning techniques. So when you hear anybody say, never have a will, maybe you should get some other advice. So let me see what I can come up with that would be something I would never do as an estate planning lawyer. Here's one. Number 1, not having an estate plan. Obviously, I'm an estate planning and elder law attorney, and I know the importance of having the correct estate plan. So not having your estate plan in place, I think, is a big mistake. And so I would say never do that. Secondly, I would say never do your own estate plan online. So when you do your own estate plan online, you're doing it without any guidance. You're following forms, which you might do correctly or you might not do correctly, but regardless, you are getting no advice as to what does it mean, the estate plan that you put into place. And I'm talking about wills or trusts or powers of attorney. At the very least, talk with an attorney about the estate plan you're doing, and rarely will an attorney ever say, go ahead, just go do it online. So I would say never do online estate planning. When I talked about never, this is a double negative. That's why it's so confusing. I'll put it in a positive way. Have an estate plan and have good guidance to what that estate plan is. Sometimes people think that, oh, well, I don't have to do that and I don't have an estate plan. What they're not thinking through is when I say this number 1 error, don't, have an estate plan. Why do you need an estate plan? Because you need something that carries out what your wishes are and protects you. I want you to understand that if you don't have your own estate plan, or if you did a bad one online or did one online and it doesn't work, the state has its own estate plan for you, and you might not be aware of that. People, not surprisingly, many people don't have an estate plan, and the state needs to be able to deal with that. So how do they deal with that? Well, if you lose capacity during your lifetime, the state's plan for you is a court-ordered guardianship and conservatorship. That's a bad result. Upon your death, you don't have estate planning documents, you haven't set anything up. What's the state's plan for you? Well, usually the state doesn't end up getting your money. It's very rare that that would happen. But the state's plan for you might not be what you want. It's pretty convoluted and complicated. It's intended to carry out what the state thinks your wishes would be. Let me give you an example, an easy one. If you're a single person and you have 4 kids, the state says, well, the 4 kids each inherit equally. 1/4, 1/4, 1/4, 1/4. So that might be your plan. Oftentimes it's not. So have an estate plan and don't do it online. And number 3, I would say what I as an estate planning attorney would never do is try to avoid probate by my own creative ways. So what do I mean by that? Well, clearly this again is people who have not sought any kind of estate planning advice. Let's say you're the parent, you're a single person, you have 4 kids, and you don't want to go through the process of creating your own estate plan. And so you've heard from your friend or somebody else who say, hey, this is a good idea, you don't need a lawyer. Just put one of your kids on your bank account or on your investment account or on your house, or just make sure that there's one kid who is a joint owner with you of everything. And then, because you trust this kid, because this is a good kid, You tell the child, please, on my death, divide everything among your siblings equally, okay? And they say, of course I will, Mom, why wouldn't I? Well, lots of reasons that they wouldn't. Number one, they don't have necessarily any legal obligation. The kids can file a lawsuit to say, yes, the kid did have an obligation to divide it equally. So now you've created quite a mess because there's a lawsuit. Or what else could happen? The person who you put, the kid who you put on your joint account with you, gets sued while you're alive, and you put them on your house and your bank account, and creditors are coming after them because they owe people money. Guess what? You have lost your house. You have lost your bank accounts. So it's not just about, what happens after you die. It's during your lifetime. If you put somebody on your accounts or your investments or your house as a joint owner, you could end up losing your house completely. It is basically a bad idea to try to avoid probate by putting one of the kids on the account. And let's say, and I said that your wish under this circumstance was to divide it equally among the 4 kids, and I said, well, maybe they'll choose not to. Maybe they'll say, hey, I was always Mom's favorite, that's why I'm on the account and you 3 aren't. But let me switch the scenario a little bit. Let's say that Mom puts her 1 kid on, sole child, nobody else is going to inherit. Good idea or bad idea? Bad idea. Why is that? Recall the creditor situation I said. If that child gets sued, you have lost your house, you have lost your bank account potentially. There are far better ways to do this. A transfer on death deed, a pay on death on account, a beneficiary designation. Far better ways that an estate planning attorney would guide you to avoid probate upon your death. So I guess maybe when it comes down to it, of all the things I would never do as an estate planning attorney is I would never fail to seek out advice, professional guidance. I hope that helps.